Welcome, everybody. We were just talking about outdoor sports. I don't say that everybody has to have an outdoor sport. Some folks are not able to do that. But if you are capable of doing an outdoor activity of some kind, it is good for your physical, mental health if you can get out. Of course, I have a couple of relatives that cannot do that at all, and I do have sympathy for them. I love being able to get out, and of course my job lets me do some of my work with you, quite a bit of it during the evenings, and that's wonderful. So I can answer questions and do a lot in the evenings, and I don't, if there's something to be done out in the sunshine, like go for a walk or something, I get to do that. So fabulous things. Conflicts of interest is kind of a strange thing. And this is kind of where lawyers will try to maybe take advantage of another lawyer, not use ethical codes in the right way. Ethical code is not supposed to be a tool to attack other lawyers with. It's supposed to be a way to help all lawyers act in the best way for both their clients and the court system. But it's not supposed to be a way to trap the other lawyer into getting into trouble or losing the case. Questions or comments about that? They used to call that gotcha. But typically, conflicts of interest seem technical until you think about the adversary system, and then they're very real. So you can think about probably the conflict of interest is where we part the one place, at least, where we part the ways from friendship, what I call friendship ethics, which you might call normal ethics. In a friendship, you can try to be loyal to both sides of a conflict, can't you? So if you're friends with both John and Mary and they're having a big dispute, can't you talk to both of them about it one at a time or both together? Try to work it out? And I got a good question. Yeah, it's a very good question, and I will deal with it in a bit because that's important. So we want to fulfill these objectives, and this is the one you're working on, right? Now, can anybody come up with a way? And you haven't had a chance to necessarily look at this, but Melissa is a new paralegal. She's been working on cases. No conflict check was run on her previous cases when she was hired. Now, this is legally, sometimes every word matters. Previously worked at a competing law firm, okay, competing, not cooperating law firm, and then representing an opposing party. So the words competing and opposing matter, okay? And the word matter matters too. In a matter, matter meaning a type of a case or a portion of a case that you're working on, okay? So a lot of this is trying to work out an ethical wall. And note that your instructor is an ethical wall skeptic. but that does not mean I'm correct. It means you should try to find ways in which your instructor is overly skeptical. Note that the ethical rules in your state very likely allow an ethical wall. Would I vote for one where I am a member of a committee trying to determine whether your state should keep the ethical wall rule or want to? I'd probably vote against the ethical wall rule, or I'd probably want to restrict it more than it is there. But you know that for purposes of this assignment, your instructor's skepticism should not become yours. Just because I'm a skeptic of ethical walls, I just think, oh, they say they're putting up an ethical wall, but who's to say that it doesn't get talked about at the water cooler? So, but I am not correct. You see, I may be correct in some generalized philosophical sense. What you should be concerned about, though, is showing that I am not the final authority. Who is the final authority in your state? It's your state's highest court, typically called Supreme Court, in New York called Court of Appeals. So you want to go with your state's authority and argue for your state's highest authority. Your state, of course, most likely created something very similar to the model code, but I don't want you to use the model code. I want you to use your actual state's professional responsibility rules. Okay? So, in answer to an earlier question, if the new paralegal was on the same side and the case got transferred over to your side case and it's not an opposing party, and I'll give a concrete example to help understand that. So if the facts were not exactly as it's stated in the written assignment, we wouldn't even worry about it. Questions, comments about that? I'll do a whiteboard. Okay, what if the situation is this? Do we even need to worry about conflict of interest? Oh, not the Hartpen family, excuse me. I already screwed it up. Cross that off. Bob James family, okay. So she was helping Bob James. Okay, does that help? So the Bob James family has hired your firm, okay? Okay? Why do we care about the other situation? Because everything matters. Every word matters. It's the fact that if we were, if she was working for Bob James, now even if she was not immediately hired to go against Bob James, she still knows secrets. Fictional name or whatever. But it's easier concrete, isn't it? So that's the question or problem. Melissa knows the secrets of Bob James, so how can she avoid being part of our case against Bob James? Now, legal conflict of interest is even stricter than that. What if she doesn't even know any secrets? Bob James will still assume that she does know secrets, and he's entitled to make that guess. Just because of the law firm that she used to be part of, if she did anything for Bob James. Does that make sense? It's called imputed knowledge, which doesn't 100% make sense. We guess that she saw and knew the whole file and knew the secrets. Conflict of interest law is kind of odd that way, but we don't take somebody's word for it to that point. In the olden days, imputed knowledge went all the way across. And if she knew it, and in the olden days, if she knew it and then she joined our law firm, it's just sort of a dead letter. We can't take the case at all. Yes, it's an assumption, a guess. The only way to make sense of it is you have to look at it from the previous client's point of view. Somebody who joins the other side in any sense is presumed by Bob to be a snitch. And you don't use the term snitch, use the term conflict of interest. You use the term imputed knowledge. If she went in front of a court and swore up and down, I don't know anything, I just did a little bit of work on it. I did some correspondence. I didn't do any substantive work on that case. Don't remember a thing. Didn't take any files with me. Whatever. In the olden days, she would not have been trusted, and the law firm she went to would not be trusted. Nowadays, though, if you create a wall, if you create an ethical wall, she can work for the law firm on other matters, not on the case against Bob James, okay? So to me, well, maybe I should do a new whiteboard. It pays to make things concrete. When you work on this, make it concrete and explain it to somebody, okay? And personal. explain it to someone else, okay? How many have somebody either close to them, you know, living in their house, or some friend that they could talk to where they could explain conflict of interest and ethical wall? Because I want you to make it so concrete that it sounds like a real case. And why are you doing this? You're doing this so you can cement in the knowledge so you can develop a written assignment and prepare for that part of the quiz without trouble and difficulty, because it'll all make sense to you. If you explain it to somebody else, you'll be able to sort it out very well in your head. Questions or comments? And you don't have to use Bob James or any other name, but look at it from his point of view as a client. What ethical wall should he be required to trust? Okay. And that's a preliminary question. Your real question isn't should be. That's sort of my question. Your question, what ethical wall is he required, or what type of ethical wall is he required to trust? How's that? So yes, I'm on the should be, and I'm using that just as a tool to help you learn it. Okay. You, as a student, you are on the is side. I'm trying to erase the be and the should be, and I'm not able to do it yet, am I? What ethical wall is he required to trust? Okay. And how do you make that wall? How does your firm make that wall? Yeah, a source. It may be a repeated source, but use one for each answer. Yep. So what is a screening process? What are the steps? And what are the ethical issues because the conflict was not disclosed? And again, you may make it concrete. It helps to make it concrete. You may do so. In other words, what problems may be caused? Due to the law firm neglect. One of the problems, or one of the things, is if she arrived and there was no ethical wall in place, if you wanted to take, and I don't think you should take my point of view, but just use it as a counterpoint to go against it. But my suggestion is that one choice that you should probably reject is to say, too late. We are dropping the case. probably my solution. Big corporate client may not be acceptable. Will Bob James waive the possible conflict? At least we have two law firms involved in that tree. Perhaps the lawyers that Melissa used to work for, Tanya asked a good question. The firm would rather drop the case than let the employee go. No. No, that's just me, Tanya. That's why I'm wrong, or partially wrong, okay? I would hate to let an employee go because of something like this. I would probably drop the case, but I didn't work for General Motors, okay? I worked for the guy that fixed cars at the local shop. I didn't work for General Motors. And I guess I would be reluctant to, frankly, there would be plenty of law firms that could take my place should there have been a situation like that, whatever. But I'd say this is one solution. Larger law firm, big corporate client may not be acceptable to drop the case. So keep the case, get a waiver. Will Bob James waive the possible conflicts? And of course, we're speculating, but maybe. And you may speculate. Add facts if you wish. One advantage we have in this situation is that Bob, that's not part of the case situation. The name Bob James is not in there. I added it to make it more concrete. But Bob has an attorney, so there is an attorney on the other side. So if it is not advisable for him to waive the conflict, they'll tell him that. So we aren't getting ourselves into trouble by telling a pro se person representing themselves to please waive the conflict. Okay. Questions? So we will not get into difficulty if we ask for a waiver. In other situations, such as if we're trying to collect child support from somebody and whatever, and we say, well, you're pro se, but why don't you just waive the conflict? You told some secrets last time you were in that we helped you, but it wasn't much. Why don't you just waive it? And then we could be accused later on of asking some poor pro se person who didn't know what they were doing to waive a conflict. And it turns out we did know too many secrets. But how does it help to have Melissa behind an ethical wall? Basically, she tells us nothing and we tell her nothing about the case. So she keeps Bob's secrets, never tells them to anyone else in the law firm, and she does not work for the case against Bob James at all. She has nothing to do with it. She has no access to the files. Is this starting to take picture? Is this starting to, you're starting to get the picture of this now, folks? Yeah. This format is in the assignment. I like it. I don't insist on it. But it's almost as easy to do it as to do it a different way. So I tend to suggest go ahead and do this. If you have problems with it, let me know or get tutoring. It's common enough in other assignments in other courses, so I would try it. So ask me for help as needed. Note that if you enthusiastically use sources and explain your own thinking, and you do so, especially when you go more and more into your own thinking, if you make a word usage error or something, that's much more excusable than if you don't. Yes, what you do is you have a direct link right in the assignment. To the guide portion. Yeah. And also use Blueback helps. So there is a direct link for the format. So this is a different format than what I usually use. These are reflection questions, but if you answer these reflection questions, it will help you with the written assignment. One of the advantages that the larger law firms have is that, especially if they're multi-city, our fictional paralegal may have nothing to do with the attorneys that are handling the case against Bob James. She may be handling an entire different area of the law, working with entirely different attorneys in a different town. So that is a good argument for the way the law is written in most states, okay? So it's probably unfair of some of us who have been in small firms our whole lives to prejudge the large law firms. Perhaps they are very good at screening, okay? Let's say that the Bob James case was corporation law or something, and now she's in an entirely different area of the law. She never even sees those attorneys, doesn't know which office they work in, never talks to any of those paralegals. When she goes to lunch, none of those people would be even in the lunchroom, okay? Questions, comments? I'm trying to act as an advocate for large law firms. That's a little bit of a stretch for me, but I'm trying to, you may end up working for a large law firm. And many legal experts feel that they are the only, that without this kind of a screening available, large law firms would not be able to help the economy of the U.S., and perhaps they're right. Large companies hire large law firms. It may be a very necessary thing, and the screening is a good deal of what allows large law firms to even exist. If you think of a large law firm in some ways as being lawyers who practice law quite separately on completely different areas of law, but combining forces in some ways, then it all kind of makes sense. If any lawyer and any paralegal could look at the case files, then it doesn't make sense. Then it's not really a wall. But if it's separated out, the wall makes sense. Okay? Use primary sources first, then secondary, finally opinions. Statutes, state's highest court rules, and cases from the state's highest court. Those are primary. There is no live classroom quiz. There is a regular quiz. I don't give credit for arguable answers that are not the ones in the answer key. The quiz was created by a different expert instructor, not by me. Okay? Questions or problems? Yeah, by the way, I appreciate the questions. I hope I have not been failing to welcome them. Because I do like all questions. It's much easier for me to teach when I get questions than when I don't. We don't use the term resources. Yeah, I'm trying my best. Sometimes I have to defer them until we get to the area. I get some criticism of the fact that I will frequently do a side trip to any question, and that is difficult for people listening by recording. If my answer to a question seems to be a side trip, just pause and make some notes, and then go to it. Whatever, pause the recording, because yes, it's hard to focus when you're not listening live. It helps to sort of pretend like you are communicating with me when you're listening to recordings, but I do get criticism from people listening to recordings. Oh, well, you're just deferring to whoever asked the question. Yes, but when you're listening live, it gets more interesting when I do that. But make notes, and make notes as if you are going to immediately ask me a question, even though you're going to have to do it in course messaging if you're listening by recording. But don't use resources as a title in your memo. And see assignment link. You are required to use this. If you don't have it from Rasmussen, get it. So if you didn't get Microsoft Word, go ahead and get it. It's no extra charge for Microsoft Office. Tanya, I really don't know. It's supposed to be bold, a heading. I would use the format that they give you. Memos would be different. If they get turned into a legal brief in court, the format would be somewhat different in each court, in each state, excuse me. If they get turned into a legal brief. But a memo that you're providing to your attorney, you and the attorney are actually controlling how the exact format is, okay? And a bunch of you that have worked with me before know that I don't actually, I like a simpler format myself, but I think you need to learn this format. So learn this format and learn other formats. But I think I would leave stuff as it is. Concentrate as much as you can on the substance of it, finding the actual rules in your home state, using them, and then also expressing your own ideas, not mine, not some legal bloggers. Don't care what the best attorney in the country thinks. I do care what you think. What the best attorney in the country thinks is irrelevant for purposes of knowing if you're learning anything. I'd rather see something where you have difficulty with some of your wording than something perfect by somebody else. And I think some students are hung up on perfect. If you never try to write out some difficult thoughts that you have, you will feel safe, but you won't advance as fast. I want you to try writing difficult things and know that the more difficult concepts you try to use, yes, you will make some technical errors, but you will advance faster and you will score well, very well. I got kind of trapped years ago, and I was very naive, whatever. A guy gave me a check. He gave me a blank check, and I thought, well, this is interesting. He says, well, in case this case comes up, gave me a blank check, and I just put it in a drawer. And I should have turned it down or ripped it up in front of him. But what he was doing was creating an artificial conflict of interest, so I couldn't represent the other side. And of course, the case never came up, which was just as well. But how long was I supposed to keep track of that check? That was really dumb. Dumb for me to accept it. But I was a pretty new attorney. I didn't really get it. I thought, well, once I keep track of the name and then the opposing name or whatever, well, he probably did that with like 3 or 4 attorneys, because he trusted attorneys, but he also knew that we weren't as smart as we think we are. Okay. Most conflicts of interest are very simple. A law firm can't be against the client and for the client at the same time. If a person wants advice on a divorce and the firm is trying to evict the same person, the new case needs to be rejected. Now, in a large firm, is this completely true? I would say it still is, because I don't see how an ethical wall would fix that. How about you? What do you guys think? Can the law firm attack the person and try to evict them and then also give them advice on an unrelated matter. I would say that's a violation of loyalty, and I would say it's non-waivable. But in a very large firm, what happens is you absolutely are forced to do electronic conflict checking because you're never going to be able to keep track of everybody otherwise. So you need intake sheet and conflict check immediately with everybody new, really. Okay? So the name should pop up, and you should be able to know that the new advice you give somebody is not to somebody that you're trying to evict. The client may be innocent and may think, well, Mr. Olson, I'm seeing you. I'm not seeing the other lawyer that's in your law firm. It's that other lawyer that's trying to evict me. And then I would have to explain, I can't give you any advice because I'm part of that law firm. Okay? There can be qualification having to do with a staff person's conflict of interest. And this is confidential information, basically. It says confident. It should say confidential. Okay? And most, because the other situation is fairly simple, this does not come up that often. We should know better than to ever do this, but these confidences and secrets one can come up, and those are difficult to even handle electronically. Easy to miss. Our screening may not even work. Even if we have a fairly sophisticated system, you have to actually read the file in some cases. My current opinions, and I've already told you enough about this. I'm gonna skip ahead. Intake sheet for a new case, because other people have told us confidences or secrets at one point or another. We write down lots of names, and then we may have to actually look up various related cases. So conflict check names. There may be several names where we had some contact with the other parties, and we'll have to check out those actual case files because even though they seem like they're unrelated to the new case, real estate sale of land and sale of car, it may be a problem. I'm going to skip ahead here. I have to take a call. Sorry. I was a little concerned. One of our actors hopped in and then back out, and I thought that was her. Bob Anderson, attorney, represents the kids in a child protection case. He confers with the parents in private before the hearing. The parents sit with him at the counsel table. He confers with them during the hearing. They do not have their attorney. The state's attorney, prosecutor, or county attorney objects. What is the result? What do you think? Any questions? Do you know what a child protection case is? It's where possibly the kids may have to go to foster care, or the family will have to do the judge may impose a family reunification plan, may protect the kids by requiring that the parents take parenting class. It may not involve taking the children out of the home. It may involve counseling or something, but still the interests of the children are not precisely the same as the interests of the parents, even if the kids cry and say, I want to stay with mom and dad. I really do. You know, the interests are not the same. So just the fact that the parents say, well, we don't need our own attorney. This is a problem. The judge is probably going to say that Mr. Anderson is going to have to represent only one side, either the kids or the parents, not both. And they'll say, no, he's not representing both, but he apparently is. So I think the prosecutor has a good argument that this is not proper. Don't do an everything search on ethical walls. I would, like mine, I would look under Minnesota state and federal court rules, or my home states. I would not look under every state, federal, state, everything. When you use Alexis, the everything search is not typically the best way to go. There is a way to do it backwards that works, but it's easier to learn the sources if you do it my way and select a source first, I think. When you get to a rule in your home state, then you scroll down and you will get to cases. Try one state and then another. So Florida, I tried Florida local, state, and federal court rules, ethical wall. It worked. And again, you scroll down and you see cases. And of course, the ones that often come up in court now, even with smart lawyers who do their best, is this imputation of conflict of interest, which has to do with usually confidences or secrets, or where one lawyer or employee used to help the other side, or has a very close relationship with the other side. This leads into what into the court trial we're about to do. I actually did handle a case as a special prosecutor. I never did find out what the conflict of interest is. Why was I named a special prosecutor for a mental illness commitment? Typically, they wouldn't do that. They would haul down attorneys from about 40 miles away from my hometown and bring them in, or they would handle it themselves. But they must have had some interesting kind of conflict of interest, and then the typical prosecutor that would fill in for them, that, you know, they would fill in for each other. So usually Long Prairie, Minnesota attorneys, county attorneys would refer it to the Wadena County attorney if they had a conflict, and vice versa. But in this case, I was brought in as special prosecutor. I suppose, I don't know why, but I was normally on the defense side, but I did handle one. Here's a quick practice quiz. If Joe, the attorney, says he may be in trouble due to an ethical violation, who did he get the letter from? ABA, disciplinary authority under the state's highest court, or the Commissioner of Commerce. So if you're at not live, I guess, play along anyway. But the answer is B. A simple conflict of interest is, yep. Imputed knowledge causing disqualification, that would be a conflict of interest, but that wouldn't be a simple one. when a lawyer's asked, personal grudge, we didn't talk about that. That's not spoken of, okay? So it's B. The exception allows an attorney to disclose what? Past crimes, no, that's what has to be kept secret. Plan future crimes or defend the attorney, so B and C. Form present opinions and test them logically with research. Those both seem like partial answers. I would go B, logically and with research. And I'm going to stop the recording.